Hi,
We can
hi
hear you.
everyone. Hi. How, how are you? Please, can you confirm if you can hear me? Can you?
Yeah, I can hear you.
Oh, great. Thank you so much for joining the webinar today. My name is Rebecca Bird, and I'm the founder of Birdie Box. We are a CIC, and we would like to welcome you to the event today, to this amazing webinar. And we are glad to be hosting Ricky Gill from Legacy Wheels, and he will be taking us through what we need to know um, in terms of the power of attorney and all the good stuff that we need to prepare for. He would be letting us know. And before that, I have a friend here from Jennister. Her name is Brenda, and she will be talking us through some of the things that might be beneficial um when we're looking to take the power of attorney, as well as looking at life insurance and all of that good stuff. So please, just to let you know, this is an informative session. And before that, I'm just going to talk us through what we do at Birdie Box. We are a CIC, and our mission really is to to empower individuals and carers and family members who are going through dementia. We are in the dementia space, and we create cultural awareness as well for people living with dementia. And it's interesting that the cultural awareness has come up in the dementia space now. This is because different cultures see dementia differently. So some of the things that we do, our mission is to create like well-being support for carers and for people living with dementia. The vision that we have is to have an inclusive, dementia-friendly community, and our goal really is to support people living with dementia with webinars such as these or community events, and this would help to strengthen their 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 caregiving responsibility and empower them as well. So some of the things that we have done in the past has been digital literacy training, dementia awareness programs, well-being and mental health support, community engagement, practical support, and financial guidance. So this is what we have been doing and what we will continue to do, and helping people understand that dementia is not the end of life for someone. Yeah, that is our core goal. And some of the things that we have achieved in the past is we tell like real dementia stories, and we support employees and employers to to support their carers. Um, we also have partnered with a couple of councils, with a couple of community groups to support this initiative. And then the next slide, this is talking about our flagship app. We do have a mobile app that helps to support people with dementia and care for the mobile application is basically a way to tell the carers to take a sit back and let this app do the magic that it's built to do. And what it really does is it helps to enhance care coordination. So for instance, we have a reminder feature on the app, and we also have like a memory bank feature on the app where the patient invites like the family, the friends, the carers to come and collaborate on the application for them. So, and this in the past has really helped to reduce burden and anxiety on carers. It's helped to increase a sense of independence for the patient and also improve self-esteem for the patient as well. And yeah, so these are some of the features that are on the app, and we have an AI integrated feature on the app that basically prompts the person to say you have a reminder, or these are the memories that have been saved in the app for you. Would you like to have a look at them? So this has really helped a lot of our customers and our clients and people living with dementia or memory loss related problems. So, yeah, I think I've talked about this. So, at the moment, we are running our focus group. Our focus group is going to start in 2 weeks' time, and we are looking to run that. And so, please, if you are interested, you can send us an email or drop us a message on any of our social media platforms or scan the QR code to join our focus group. So, thank you very much. And I will yield the floor now to Brenda, who is going to just talk us through for a few minutes, and then before Ricky joins us. Thank you. Hi, Brenda.
Thank you for inviting me to be part of Birdie Box, and exciting news around the app. Congratulations in launching the app. So I know you worked very, very hard on that. So yeah. So guys, I just want to say good after. Is it good afternoon? Yes, good afternoon. And my name is Brenda Drummond, and I'm one of the executive vice presidents at a company called Genistar. And our role as Genistar is that we are around financial education and financial empowerment. Now, I am just going to share, if Pila can allow me to share. Oh yeah, wonderful. Okay. Is just to share a little bit about what we do, and also, so something's happening here. Let me just, one sec. Let me just stop that share. That wasn't supposed to happen. Yes, so a little bit about who we are and what we do. So I'm just going to share my screen for a few slides and just say here. All right, so we are as I said, a financial education company, and what we are looking to actually provide is helping people look at areas where they don't really know where to go and how to go about certain things. And things that we've actually looked at is that we are actually authorized and regulated by the Financial Conduct Authority. And what we do is that we don't give advice. We're financial education coaches, but we partner with industry leading experts, and you're going to hear from one of our experts right now in a moment, Ricky from Legacy Wills, and he will tell you a little bit more about what they do. But that's what we do, guys. We're actually helping people look at financial planning solutions that can make a huge difference to themselves and their families. So some of the problems that we've actually identified is things like planning for retirement, understanding how to deal with debt, understanding protection needs, and look at this, understanding wills and trusts and power of attorneys. And how we do that is 3 ways. Is that we give financial education, we provide a complementary financial plan, which is holistic to where are you looking at where you are now, and what are the things that you need to put in place for the future to make sure that things are running smoothly, and not only looking after your loved ones, but also looking at after yourself, yes, and planning for that future as well. And I will say that there is an opportunity to come and join us as a team, and that we call that a business opportunity, where you can earn extra income working from home, doing this very flexibly, and being able to earn an extra part-time income alongside whatever you're doing. So I'm just going to stop there just to give you a flavour of what we do, because at Genistar, but I really wanted to give you an idea of how we do that. And if you do want to access a free financial plan, I will put a little link in the chat right after Ricky's talk to see what you're interested in, or any part-time income. All right. So can I just introduce Ricky? Is that okay, Rebecca?
Oh, I just wanted to say something before we introduce Ricky. Yeah, I wanted to thank you for your presentation. And just a bit of background, to myself. I am also a carer, and these and I met with Brenda, I think, at some point in my life, at the beginning of my caring journey, and she gave me a financial education and a financial plan that has supported me, and I'm still using that to date. So please, this is a free educational platform that you can use, especially as carers. If you're having any financial difficulty, this is good. We are going to share our information anyways. And yes, so to the main crux of the day, let's welcome Ricky Gill. Hi, Ricky.
Afternoon, guys. Thank you so much for having me. Brenda, obviously, we've spoke many times before in the past. Thank you so much for the introduction. If I could just ask you to, yeah, there we go. Brilliant. So today's session is just a little bit about me explaining why a power of attorney is so important, what happens if you don't have one, and what happens if you haven't got one, in the process people have got to go through. But obviously, before I go on to that, a little introduction of myself. As I've already been introduced, my name's Ricky Gill, Head of Sales Operations at Legacy Wills and Estate Planning. Legacy Wills and Estate Planning have been around since around about 2012, 2013. If you could just move one more slide over, that'd be great. So we've been going since around about 2013, and we are based in Leicestershire with over 150 employees. We write essentially wills, give advice on estate planning, and obviously deal with kind of certain aspects of probate services. So when we go through a journey of our clients, it's in our interest to ensure that we give the correct advice based on circumstances, and power of attorneys are obviously a very important part. Although they're not a part of a will, they run kind of parallel with a will. It is very important. We advise people of why it's important of a power of attorney. So if you could just move on to the next slide, that'd be great, please. And before I kind of do that, just to give you a few stats that I've just kind of collated over the last day since preparing for this appointment. 17% of people have appointed a power of attorney in the UK, and this is all from which.co.uk and various kind of sources on the internet. 83% of people over 40 have still not appointed a power of attorney. That's 83%, which I think is it's insane. And we say that, but when you're of such an age, you don't think about things like this. But it's our job to educate our people and our clients to ensure they are very well prepared. Because I always say, as a power of attorney, you're planning for the worst, but hoping for the best. Like any sort of insurance, hopefully we never need to use it. But God forbid if we ever did, we've got that plate in place. 130,000 applications have been rejected by the Office of Public Guardian since 2018. So in the last 7-8 years, 130,000 applications have been rejected. So just to give you a bit of an insight on that, power of attorney documents, you can do power of attorney documents online yourself. However, when you do it online, there's a lot of paperwork involved. You've got to sign in the correct order, and you've got to ensure that you are consistently signing and dating in the correct places. What people don't know is when they submit a document to the Office of Public Guardian, the document that they did themselves 5-6 years ago is actually incorrectly completed, which is why Legacy Wills offer a service as to making sure it's done correctly. So a lasting power of attorney is a legal document that allows you to appoint one or more people, and we always advise between 1 to 4 people, to essentially make decisions on your behalf. God forbid if anybody was to lose their mental capacity, suffer an accident, illness before you passed away. So the obvious things we always speak about is dementia, Alzheimer's, etc. However, you can have an accident, you can have a stroke, you can have a heart attack. I think COVID-19 was a massive eye-opener for everybody, and I'm sure there's plenty of people in this room who have, unfortunately, including myself, went through a circumstance where we lost individuals. But a power of attorney is a legal document that allows somebody to make decisions on their behalf. So God forbid if anybody was to lose their mental capacity. It's a very, very expensive kind of process if you don't have a power of attorney. And I'm just going to, before I kind of continue, just play a short video, which is, Brenda's obviously seen this many, many times. I think it's a very, very powerful video. And video that's available on our website. So if you could just press play and then we'll reconvene from there.
As we get older, we become more prone to illness and injuries, and the loss of mobility can make it difficult to manage our affairs. We are all living longer, but some of those later years are often in poor health, with the ever-present threat of the loss of capacity to consider. An elderly relative losing capacity is difficult enough for loved ones to deal with, without the added worry that their finances become muddled. You might be forgiven for thinking that this doesn't apply to you, as you are nowhere near approaching your dotage, but you couldn't be more wrong. What if for some reason you became really ill, or were involved in an accident and were held in a coma for a period of time? How would you pay your bills and manage your affairs? The prospect of unpaid bills can cause unnecessary stress and anxiety, and delay someone's recovery. You might be thinking, well, that's okay, I have a joint bank account, so I'd be able to carry on as normal. Wrong. The banks deal with joint accounts very differently. When a joint account holder loses capacity, the account is closed for all transactions other than for emergencies, until a deputy has been appointed by the Court of Protection. This can be a long and costly process, often taking longer than 9 months, with no bills being paid. What if you had a business? Who would make decisions on your behalf? What happens to any property or other assets you hold jointly with someone and one of you later loses capacity? What if you are in your retirement and have taken out an equity release on your property and wish to make a further drawdown of cash after your partner or spouse has lost the capability to sign? Perhaps you wanted the cash to pay for their care. Many of these schemes will not now allow you to make the drawdown if one of you is no longer able to sign. By setting up a lasting power of attorney, you can authorize someone you trust to administer your financial responsibilities on your behalf. This could include selling property, managing your investments, paying bills, even running your business. Let's also suppose the worst were to happen and you needed someone to make decisions for you regarding your medical treatment to ensure your wishes were met. You probably assume that, if you were unable to make these decisions for yourself, then a family member could, but you would be wrong. Without setting up a lasting power of attorney to cover your health needs, loved ones will not be able to make decisions about which healthcare you receive, or even which home you live in. A lasting power of attorney is a powerful document. It must be set up with someone you can totally trust with your assets and who is a responsible person. It's vital then that the document is created by someone who knows exactly what they are doing. By establishing a property and finance and a health and welfare power of attorney in advance means that you choose who makes those vital decisions for you, rather than some faceless authority. So if the worst were to happen, you can rest assured that both your financial affairs and personal welfare is in safe hands.
Okay, so very, very powerful video. And I think a video that actually makes you think, wow, you know, it's really important. Um, but yeah, some kind of certain scenarios in there without kind of making or seeing the funny side of it, that makes you kind of really realize on why it's so important to have a power of attorney document. So if you just pop over to the next slide, I'll kind of discuss a little bit about the two documents that we receive. So a lasting power of attorney, you receive two legal documents: a health and welfare power of attorney and a property and financial affairs. Property and financial affairs allows individuals to essentially take control of their finances, continue making payments to their property, and look after their biggest asset, which is obviously their house, which includes selling the property, collecting money, continue paying direct debits, and other kind of things for your benefits. Health and welfare power of attorney allows people to make decisions about medical treatment. So day-to-day care, where you're cared for, how you're cared for, and even as far down as life-sustaining treatment. So obviously it's optional for clients whichever document they wish to take, but they are both just as important as each other. And we always advise, and it's always advisable, that you take both documents at the same time. Because again, if you only have one and you've not got the other, it could have an impact on that itself there. Just to again give you a bit more information on what happens if you don't take a power of attorney, and God forbid you was to lose your mental capacity or suffer an accident illness before you passed away. If you don't have a power of attorney, it's unfortunately too late. You would have to go, or your loved ones would have to go to the court of protection. Now, going through the court of protection, the application, hearing, and assessment fees are just short of £1,000 alone. Once that initial kind of fee is being paid and implemented, the potential solicitors' fees or the ongoing costs of going to court can, in some cases, exceed over £2,000. So not only is it a very, very difficult situation because mum, dad, son, brother, whoever that may be, has lost their mental capacity, but it's also a financial kind of implication. But that financial implication isn't a one-off fee. In time, you have to pay a yearly annual supervision fee. And again, that's payable to the court itself there. So is a power of attorney very, very important? Absolutely, yes. And in some cases, when we do an estate planning kind of consultation with our clients, there's arguments to say that a power of attorney is probably just as important, if not more important, than your will. It's all well and good writing your will for once you've passed away, but if you don't have a power of attorney and you did lose your mental capacity, you've not looked after your estate whilst you're alive. So that's the key point. You've got to look after your estate, your finances and affairs, and your loved ones whilst you are alive in the event of losing your mental capacity. But it's also very, very important to look after it once you've passed away in the forms of a will. So they complement each other itself there. So any questions? So I know I've gone through a little bit of information. I've given you that itself. That can go on to the next one. Rebecca. Any
Hi.
questions?
Yes, please. Thank you so much. Wow. I feel like that was a lot of information, and indeed, this session is supposed to be informative. So I have a question on our platform, on our Facebook platform. A couple of questions have come in through there. And yeah, I'm just gonna ask you some of them. So there is a lady who says that she doesn't have a power of attorney yet, but she's starting to see herself forgetting things, and she doesn't trust anybody. What can she do to protect herself?
I think the best thing to do is obviously appoint somebody who she does trust. That's the difficulty. You know, when you lose your mental capacity, you may not trust the person that actually is stepping into your shoes. So obviously, whilst you've got the mental capacity and you've got the ability to appoint somebody now. And if you've not got anybody that you can trust, then it's a very, very difficult one. You need to find that person. that you do trust.
Mm.
Okay. So the second question is, can I have more than one attorney? Yeah, I guess you've answered that already.
Yeah,
Yeah.
to stretch a point to make a point, you can have up to 10 attorneys, but one thing you've got to understand is you've got to have people who are going to and willing to work together. So there's no point me having, I use as an example, two people who know each other and then another two people who don't know the other two people, because yes, they will collate together and work together because I've lost my mental capacity, but do they know each other in a forms of being comfortable?
Mm.
So you can have one, you can have four. We always advise that's the good kind of number, but it's always advisable to have people that you know and trust, and that they know and trust. Just a question from Pilar: can you change the person maybe because of separation? Yeah, very good question. And again, probably my last slide was kind of the storage and aftercare kind of side of it. You can change it. It does come at a fee, an administration fee of changing the power of attorney document, but yeah, you can change it. Is it a difficult process? Could you just elaborate that on that pillar, please? Do you mean in terms of going through the application through court, or actually filing or setting the documents up?
Yeah, thank you for answering the question, by the way. Yeah, I meant like, is it a lengthy process? Like, do you have to talk to a lot of people? Like, is it like starting from scratch, or is it just an amendment, basically?
Oh, right. From that point, no, it's just, I mean, it depends on who you do it with. You know, for example, us, if you did your power of attorney 5 years ago and you needed to change it, it's just a simple amendment form. You pay the fee if there's a fee applicable, because some people have our aftercare facility, which includes the changes, and then we just reproduce the document. So it can be turned around in about 2 weeks.
Okay.
And as long as you've had it signed before, you just let it be. Or if you need to get it signed, then obviously you can get it signed. But just to elaborate on that point on time frame, if you don't have a power of attorney, not only does it cost a lot of money going to court, typically takes 9 to 12 months to go through. Now, I use me as an example because I never like to use anybody in the forum kind of as an example. If I lost my mental capacity and I didn't have a power of attorney and my wife had to go to court, my property, direct debits come out of my account, they could potentially be frozen. So nobody could step into my shoes, and 9 to 12 months. Yes, of course, certain mortgage providers will give you a little bit of grace. Will they give you 9 to 12 months? Probably not. And that's where the complications become, because you've got a very large asset of a property where direct debits could be stopped. So yeah.
Thank you.
Curtis,
There is another question in the chat.
can you give me some instances where a will and power of attorney should be updated, and how regularly should you review it? Okay, very good question. A will, power of attorney is the obvious one. So if your attorney has changed, or your executor has changed, or your beneficiaries have changed. But essentially, the way we write our documents, we try and future-proof the documents as best as they can. So when we kind of speak to clients, we try and plan out a little bit in future, but you can't plan that somebody's going to go through a divorce. Nobody intends to get married and go through a divorce. So obviously, if you go through a divorce, separation, you have more children, maybe you want to appoint them as an attorney when they're 18. But they're the main ones as to why you should update it. So, if a person lost the children do not have a power of attorney and do not work well together, who makes decisions on health and welfare? Whoever the people is. So the question you're asking is, if you've got people who are your attorneys and they don't work well together, who makes the decisions? Essentially, if I lost my mental capacity and I've nominated my brother and sister, they don't get along and they disagree. Well, unfortunately, between they've got to make a decision to agree something. So it's essentially the people on your documents. So what if somebody has two children, but one of them has a criminal record? they still trust them both and want them. Yeah. So again, somebody has got a criminal record or any sort of debt management, IVA, or bankruptcy. It's advisable not to, but there's no set rule to say they can't. So I could appoint two people who have got a debt management or an IVA and they're not very good with money. Is that a wise decision? Probably not, because they're dealing with my finances and affairs. But the start of your question was, you still trust them. If you still trust them, then yes, you can. Any other questions?
Oh, yes, please. Sorry. So there is one other question that we got from our online community, and it says, so these are two families. One is a daughter, another one is so I would just ask the question. My dad has two families, and he has appointed me and my stepsister to be the power of attorney, but we don't agree. We don't see each other. I feel like they are disrespecting my dad. What can I do to remove her from the power of attorney?
Again, just make a simple amendment. As long as you have got the mental capacity at the moment and you've physically got the document with that person on there and you want to remove them, go to the company, go to the Office of Public Guardian, and you can just remove that person off there because you've still got that mental capacity to make that decision. So, you know, once you've appointed somebody, it doesn't mean that you can't change, take away, etc. Whilst you've got mental capacity, you can.
And how about if the person hasn't got a mental capacity anymore?
It's too late.
It's too late.
Yeah, unfortunately,
So
it's too
this
late.
lady is stuck with her sister.
Yeah, similarly to if you've not got a power of attorney, we very briefly offline spoke about a scenario, Rebecca, of and of an individual you know, and my question was, has he or she lost the mental capacity? And if they have, it's too late. You've got to go to court. You've got to pay the fees of the court fees, etc. AJ, what's the difference between a will and a power of attorney? So a will looks after your estate once you've passed away. So I passed away yesterday. I want my house to go to my mum or my wife and my kids. That looks after you whilst you've passed away. A power of attorney looks after you whilst you're alive. So although we say it's got nothing to do with the will, it sits alongside your will, but a power of attorney looks after you whilst you are alive. Curtis, off topic a little bit, but can you give a little bit of an overview on how a will differs from a discretionary trust? Yes, not a problem. Feel free to reach out to me separately as well, Curtis, if you want a bit more information. A trust is a legal document that's written into the will. So without kind of going off on a tangent, you can't do a will with me and a discretionary trust with Rebecca. A trust has got to be written into the will. And what a discretionary trust does, again, without going into too much detail, it protects your estate from third-party attacks. So if your beneficiaries went through divorce, separation, or anything like that, it protects them from third-party attacks. But feel free to drop me a message offline, Curtis, so I can talk to you a little bit more in detail with you. But once you've registered the power of attorney, can it still be invalid? And if so, why? Once it's registered, it's registered. What the OPG do is what a lot of people do, and going back to the stat that I mentioned, 130,000 applications have been rejected. You don't have to actually register your power of attorney document there and then. So if I take my power of attorney document out yesterday, I don't have to actually go to the Office of Public Guardian and register it. We always advise it's good practice to do so. But if in the instant that your power of attorney is registered and you need to take it to the Office of Public Guardian and say, right, Ricky's lost his mental capacity, it's dependent on how the document is written. But at that point, they would have looked at the document and they would have already rejected the document. So simple answer to your question, if it's been registered, the document's good to go. Brenda, who determines if the person still has mental capacity? Very, very difficult. And it's really down to kind of client trust, I suppose. Brenda, you could come to me and say, I've got somebody, they've not lost their mental capacity, go and do their documents. But over the phone, we've got to make a judgment over the phone. Because, you know, it's not just a case of, here's your documents, here's your address, we'll send them to you. We will go through a series of questions. And, you know, the consultation typically takes 30 minutes just to do a will, power of attorney. So, you know, there's a lot of questions, and 99.9 times out of 10, put it this way, we've not had a case in the last 14 years where we've had a case where somebody had already lost their mental capacity, because we go through a fact find itself there during the consultation. We ask certain questions like, have you been diagnosed with dementia or any sort of means tested benefits? So yeah. What happens if someone doesn't have a will and she is no more? Can the power of attorney work for him after his death? No. Simple answer. The power of attorney looks after you whilst you're alive. A will looks after you once you've passed away.
Yeah, please, everyone, please do send in your questions. Ricky's still here. We have 20 more minutes. Send in as much as possible. I do have another question from our online community though, please. And the question says, so this person has a power of attorney. They have appointed someone, their sister, to be a power of attorney, but the sister is no longer alive, and and the person himself doesn't have mental capacity anymore. What can they do?
So I'm the client, I've got a power of attorney, and I've got somebody on there who's passed away, but I don't have mental capacity.
Yes.
If it's just the one person I've nominated who's passed away and I've now lost my mental capacity,
Yeah.
there's nothing you can do.
So it's invalid.
It's invalid. Basically, it's an invalid document, which is, again, going back to what I spoke about. We try in our best way to future-proof documents. So, you know, if I was speaking to you, Rebecca, for example, and you said you've only got Brenda, that's fine, but we'd try and future-proof the documents. God forbid if anything happened to Brenda, we always try and ask you to appoint a reserve. Or what we'd say is, it's a very, very difficult process and a very mentally draining process. Not only is somebody close to Brenda lost their mental capacity, touch wood, that never happens, but it's a very lengthy process as well. So Brenda's going to need that support. So yes, she can get support from people out there, but she's not going to physically be able to take anybody into these meetings, into the court of protection, into the office of public guardian. She's got to do that on her own. So the recommendation would be to get somebody to work with Brenda, but also nominate a reserve. So in that scenario, you lost your mental capacity, Brenda's unfortunately not here anymore. Automatically, you've nominated
nobody.
AJ as a reserve, and that person steps in. But if you've nominated nobody, it's an invalid document.
Okay. And so these also comes in the place of trust. So where, for instance, people don't really trust people, so that's why they nominate. So how does the future proof work if, for instance, there is one person I trust?
If there's only one person, we can only give you the recommendations. It's personal opinion. I think, to be honest with you, 95% of the time when we explain it in such a way, in a lot more detail, obviously, clients will go away and then speak to that person and say, right, this is the situation. Have you got anybody that can work with you that I know? But you know, we do get people that have only got one beneficiary, one trustee, one power of attorney. It's just a case of, yeah, it's personal preference. They don't physically trust anybody. you can't force them to appoint somebody else, because that in itself kind of goes against the grain.
Yeah. There are some questions in the chat room.
Yeah, just gonna go up. I've popped my name and number in there. If anybody wants
Yes,
to reach
please.
out, please do so. Alternatively, you can kind of get in touch with Brenda, who'll kind of direct you through to myself. Dementia is interesting because there are scales at the beginning. They still seem to have mechanical capacity. So who decides officially? Yeah, GP. The GP or the hospital, they'll say you're medically, you're not fit, and they'll do their relevant assessments, tests, etc., etc. But yeah, essentially it's the GP. Curtis, can a financial power of attorney also be reserved for health? Yeah, so it's advisable for the same people to be your attorney on both documents, Curtis. So if you did your document and you wanted me and Rebecca as a power of attorney, me and Rebecca would work together on a health and welfare point of view and the property and financial affairs. Because when you lose your mental capacity, 99.9 times out of 10, both elements are important. So me and Rebecca would work together to ensure that your property, your finances are secured and protected and given to the right people and things are paid, or the following, you're with your care itself there.
Yeah, thank
Kind of power of attorney.
Oh, there's another question in the chat for you.
Good question, Curtis, and a question we always do get asked. Unfortunately, we're not a tax specialist, so we can only give guidance on inheritance tax. A trust or a power of attorney or a will, a will or a discretionary trust can't mitigate against tax. With a trust, we do give an extra allowance, resident nil rate band, but that's dependent on criteria. But we can't turn around to you and say, right, do this, and this to avoid Mr. Taxman, who I think a lot of us don't like. The best advice we always give is go and speak to a tax specialist, or we've got people and trusted partners that we do work with who can possibly give you that advice.
Okay. And I think, wow, the questions are still coming. So I have one question from our online community, and the question is, where do I start from right now?
As in
Everybody has
to do your power of attorney?
Yes, I'm guessing that's that. Yeah.
Contact the Wonder Brenda. Brenda will kind of direct you through to me through the right channels. Generally, obviously, we do deal with clients who just want a power of attorney, but it's always advisable to try and do both at the same time. A will and a power of attorney is always advisable. But yeah, contact Brenda. She'll be able to direct you through to myself. Brenda, if you can just pop a note on any people that do contact you that come through this channel, we'll then know how to deal with it accordingly.
Yes, please. Please, if you could pop your contact information into the chat room, Brenda, and then
I'm just going to, if you don't mind, I'm going to just put a link to a form that they just click on the link and they can just say what they're interested in, whether it's just the will, the power of attorney, or is it other things like the plan, to do it as a general thing, and then we can refer them to the relevant partners that we have.
Yes, please. And just to let you know, if you say that you are from Birdie Box, you would get a special attention. You get special attention because they know that we here, we are empowering like carers. So you will definitely get a special attention. Promise. Thank you. There is a question in the chat room, please. Do the Court of Protection let people use the money from a financial and property POA when someone have dementia when applying for a health POA?
People use the money from a financial.
Sorry, I'm terrible at
No. It's fine. Sometimes I've just got to read it in my brain myself.
Yeah.
No, I think the question you're asking is, and correct me if I'm wrong, is this if you've not got a power of attorney in place? And if so, no. So again, I use me as an example, and correct me if I've got that misunderstood. But if I've not got a power of attorney and Rebecca has to go to court, they can't use my money because I'm mentally incapacitated. Everything's frozen. That's the whole point of the process of going through court. Or Rebecca's going to have to very kindly pay 1,000, 2,000, 3,000. And there's been case studies recently we've been researching where some clients pay over £4,000 plus the annual supervision fee. Correct me if I'm wrong, Anne, if I've got that wrong. So Brenda, oh yeah, of course.
Yeah, she's put her contact.
Yeah.
Yeah. So,
And,
okay. Did anybody want to ask a question? Oh, I thought someone unmuted themselves. Okay. So, last question from our online community, and it says, I do have a power of attorney. My son is no, yeah. I've given the power of attorney to my son, but I feel he doesn't have the capacity to be my power. Yeah, to yeah, he doesn't have the capacity to be responsible. I think that is what the person's saying. But I want to give it to my wife, to my son's wife. How do I change it to my son's wife without upsetting him? Yes, that was the question.
very difficult. That's just a circumstance you're going to have to obviously have the conversation because clearly your son's wife's going to know unless she chooses not to tell her husband, which is a different story in itself and a different complication. But the most honest, the best thing is for me anyway, with anything, honesty is the best policy. You've got to have that conversation. You've got to explain and educate to your son the reasoning behind it, because you're not doing it in a malicious way. You're doing it in a way where there's a thought process behind it. And yeah, so best way is to have that conversation. Either go back to the company that you wrote the power of attorneys with, and or go to the Office of Public Guardian, but they'll charge a fee. So just to give you an idea, I think top of my head, for a single person, if you don't have our storage aftercare, it can range anywhere from £100 to £125 just to make the amendments, because you need to amend both documents. But if you have an aftercare facility, which is what we have, it's just a one-off payment of £20 a year for a single client, and you can make the changes itself there.
Yeah.
Yeah.
Okay.
Yeah.
Anne, are you able to speak now?
I think she says her mic's playing up.
If you could type your questions in the chat room, and then we would take it from there. So just one last question. I think this is the last one from our online community. So the person says, I am a carer and I don't have the money. Can I get some support? Is there any support available for carers to apply for power of attorney for their loved ones?
So is the carer doing a power of attorney for herself?
No, for a loved one. Yeah.
I wouldn't know the answer to that.
Yeah.
There may be. The best thing to probably do, I mean, through ourselves, it'd just be the process as it is to set up with like any client. But whether carers get any sort of, how can I say this in the nicest way, preferential treatment or anything like that, I don't know. It's probably best to have that conversation. But if you go to the Office of Public Guardian, they will tell you to do two things. Go and speak to a specialist, so ourselves, a solicitor, or a third-party company, to pay for the service and get it done properly, or you can do it through the government website. And we do tend to advise our clients, you can do it through the government website, but the risk of 130,000 applications that were rejected since November 2018. So let's just say 2019, so that's 6 years alone. that is an incredible number where people think they've got the power of attorney document in place, but when the loved ones go to use it, register it, and need it, it gets rejected by the OPG and they're back to square one. They've got to go to court. So yes, we charge a fee, but you've got that peace of mind that you're paid for a service where it's done correctly. I mean, I would use the analogy of, do you cut your hair yourself? I mean, I've got no hair, so I do my hair myself, so it's easier. But you know, younger, would I do my hair myself? I probably wouldn't. I'd go and pay for a service because you know you're getting the right service itself there. Okay.
Yes, so yeah, like that does make a lot of sense because yeah, if and I like the analogy of not having hair and how you would have gone if you were much younger. Yeah, like there comes a point in our lives, where we wish we could go back to 10 years ago or 20 years ago or 30 years ago. But
Definitely.
these just goes to show that it's not too late, like you're not too young or you're not too old to take out a power of attorney. And
Yeah.
yeah.
I think the difficult thing is for us, like I said, we produce anywhere from 100 to 140 wills a day. And I'd probably say 80% of clients that come to us just think they're going to get a will. But the great thing about what we do is it's not a difficult thing because it's very easy because we know what we're speaking about and we know how we're advising. Like you guys would be in different various areas, but educating people is so important. And when I speak to all of our will writers, it's not, you're not writing a will for the client, you're educating the client. And like I said, 80% of clients come to us thinking they are just purchasing a will, but they go away with the additional protection because they didn't know about power of attorneys. I mean, me myself, I joined the company in 2010. So it's been 16 years, coming up to 16 years. And when we went into the will writing industry, I got married at 2011. I had my first child in 2012 with a property. We started doing will writing in 2013. I didn't have a will, but because I didn't know why it was important. In my eyes, I was just 22, 23. I don't need a will. But the reality was, once I'd gone through that training process and I got educated myself through my peers. I said to my wife straight away, we need to go and write a will. And I was 23 at the time. Especially when you've got kids. When I found out I know I'm going on a bit of a tangent on wills when it's supposed to be power of attorney focused. But, if you don't have a will and you've got children, me and my wife passed away, my children become a ward of court. They go to social services. And when somebody said that to me, the penny dropped. Because my children, to me, like everybody, are everything. But similarly to a power of attorney, if me and my wife lost my mental capacity, we had an accident, well, what happens to my sons? Are they going to be financially stable? Are they going to be, all thoughts go through your mind, and immediately it just triggers you to kind of get these documents in place. And power of attorneys and wills, again, like I said earlier, the best thing that we kind of try and do is future-proof the documents. So do it once, do it properly, and you shouldn't need to do it again. The only time you need to renew it is if you go through a divorce, which hopefully that doesn't happen, but it is unfortunately quite common these days. If you have more children, if you need to change your beneficiary or your attorney, or you move house. So yeah, that's the most important thing, is how can we as a collective whole educate people on why it's important. And I think them videos do a very good job.
Yeah.
So feel free to kind of share them videos. And if anybody wants any more information, obviously Brenda's there. My details are there. Pick the phone up. And I know your mic's playing up, but if you want to give me a call after, please feel free to do so. And I might be able to elaborate a little bit more on the question that you'd asked before.
Yes, ma'am.
Education means people make informed decisions. You're absolutely spot on, and it's true, and it is true. Like I said, we always speak to our staff. You're not writing a will, guys. You're educating our clients.
Educating clients.
Yeah. I suppose a lot of people see that having a lasting power of attorney for people with money. Yeah. But if you've got a property, although you've not got cash money, you've still got an asset. And who's to say in 30 years you might win the lottery, or you might inherit a property from, God forbid, parents that pass away, grandparents that pass away. So yeah. Zitri, yeah, by all means give me a call. And anybody else, I suppose, anybody else that wants to get a bit more advice, send me an email or give me a call.
Yeah. Just one quick one, and I think this question is very important from our community, please. And it says, I'm trying to make my wife a POA. Could my family appeal against my decision when I am incapacitated?
No, once you've appointed somebody, no.
Okay.
And it's always advisable, even when writing a will. Again, I know I keep referring back to wills, but power of attorneys and wills are hand in hand. When you write a power of attorney or a will, it's your decision. So we always advise, try not to discuss it with friends, family, third parties, because you may get different advice or different views that you may not feel. You write a will because it's your wishes. You want it done because it's the way you want it done. You don't want somebody else saying, "Oh, you should go and you should appoint your next door neighbor," or that. Yeah, that's not. But yeah, simple answer to your question is, once you've appointed someone, as long as you are happy, nobody can go against that, as long as it's signed and witnessed, etc., etc., etc.
Thank you so very much. I think we've come to the end of the webinar now. There are so many questions, but yeah, I'm going to share your details with our community members. I would also share the form from Brenda with our community members. So please expect a flood of carers coming to you.
Not a problem. Like I said, I can give you the advice, but speak to Brenda on how you can get referred
Yes,
and
please.
put through to us with the right channels, and then we'll be able to kind of take it from there.
Yes, please. So I'm going to share the form in our follow-up mail, just to let you know how you can get through to Brenda, to Ricky. So we'd like to thank you both very much. Thank you to Brenda, because she literally said to Ricky, "You have to be here on this platform." And Ricky
I'm always
said,
there, Brenda. You know that.
Yeah.
I know
That's
it's been a little bit manic the last few weeks, but we've been really busy. But as soon as I say yeah, I'll always be there and accommodate.
Oh, yeah, I
As best
really
as possible.
appreciate it. Like, honestly, I really just want to say thank you both for this opportunity, for coming, for the financial education. Like, by the way, Brenda is going to be in our next webinar. So she is going to come on here and educate us, give us the financial download that we need. At the end of the year and into the new year, I feel like this is very important, on how we can better manage ourselves, especially, as carers, like we don't have a lot coming in. So this kind of opportunity would be very good for us to plan into the coming year as well. But I just want to say a big thank you to you both.
No problem. You're
Thank
welcome.
you to my partners who are on the call today. Thank you to my colleagues. Thank you to everyone who joined the call. Thank you to everyone who is going to listen afterwards. Thank you to our online community. And just to let you guys know, our information is in the chat room, and we are having a focus group that is going to start in 2 weeks. So please sign up and let's do this. Let's work on dementia together. Let's make sure that dementia is something that we are keeping up with and not avoiding, because a lot of people, they feel like, oh, dementia is not mine, it's not for me, but you never know.
Biggest misconception that is. And unfortunately it is. And
Yeah,
we all hope to think that it's never gonna happen. But like I said at the start, planning for the worst, but you're hoping for the best.
exactly.
Hopefully nothing ever happens, but if it does, you've done the right thing by, not only looking after your estate, but looking after your wife, who may be in a position where, or your husband, who may be in a position where they've got to deal with dad or husband and their children going through the dementia. And I don't know if anybody's gone through that process. I mean, I've gone through it a few years ago with somebody elderly in it's very, very difficult mentally, very, very difficult. So do the right thing, get it done
Yeah.
once. Yeah,
Yeah.
definitely.
Yeah. I don't think anyone understands the difficulty. Like, it's mentally draining
Oh,
for your family, for your friends. And I do have an example that I'd just like to share in a few seconds that we have left. There is this lovely woman who has lived in a neighborhood for 40, 50 years, and she had dementia, and everybody knows her. And then she had dementia, and the neighbors that she had for 40, 50 years, she stopped recognizing them. So
oh,
it's not just about the person, it's the community they are involved with that is affected.
mm,
So please, guys, get your life in order. Get your
mm.
wills, get your power of attorney, reach out to Ricky, to Brenda, and just get things in order.
Yeah. And,
So,
and if you've already got it done, share your thoughts with friends, family.
yes, please.
Because you could be the one that's gonna have to pick up the pieces of somebody who's not.
Yeah.
So it broadens the horizon. But yeah, speak to me, give me a call, speak to Brenda, and we'll be able to get everything sorted. But thank you so much for having me, guys.
Thank
And I'm sure
you.
we'll catch up over the next couple of days
Yes,
offline about a
please.
couple of other bits we can do together.
Yes, please. I
All
really
right.
appreciate it. Thank you, everybody,
Thank
for
you,
You're
joining
welcome.
us.
You're welcome.
Take
Have
care.
a lovely weekend.
You too.
Thank
You
God it's
too.
Friday.
Take care.
Bye,
Take care.
everybody.
Thank you.
Bye-bye.
Bye
Thank
bye.
you.